Okay, you home now. That's good. Yay, I'm glad. I hope you can, muster up the energy to stick through the show. I know that you are very tired. Whew, mom life is not for me. All right, hold on one second. I got to put my phone on Do Not Disturb. Okay. Okay. All right. Hello, Periscope. Hello, YouTube. Hello, Instagram. So I was caught up talking to my girl, Kimberlyn. We were just talking about, what she's doing for the rest of the day. She is an educator. She is a superhero, guys. Apparently, Teachers Appreciation Week is coming up. Give your teachers some appreciation, primarily in the form of dollars. All right. I'm going to give y'all about probably 2 minutes to come on in. Meanwhile, as you come in, if you have a business that you are trying to promote, please drop your name, where you're at, and let us know what your business is. During the beginning of my show, we're all trying to do our thing out here, and I want to give everybody a chance, and any opportunity to get your name out there. So you guys can do that. I'm going to get my list of cases ready today, but I also wanted to let you guys know about the title of today's broadcast. So if you saw the post earlier today, the post said, can you trademark quotation marks and red zip ties? And that is exactly what we're talking about today. But during the live broadcast, I'm running a live broadcast sale. I just revamped all my systems, which makes getting products a whole lot easier. And I am celebrating with a 50% off sale. If you use the code live discount, like it's spelled in the title, and in my e-store, the address is in the title, you will get 50% off of anything and everything in my store. And I have things in there as low as $5.97. So it's a great time to get my stuff at a discount, 50% off. I think that's a pretty good deal. Okay. But let's get to the meat of why we are here. I want to say, and this is the time that you can share this out with your friends, let them know that you're watching, all that good stuff. All right. So now let me go into my spiel. Hello, happy Thursday. I'm Natalie Pierre-Lewis. I'm the owner and operator of NPL Consulting LLC, and you are watching my live show, NPL Legal Dish. NPL Legal Dish is a weekly show where I talk about pop culture and celebrity stories that are in the news and help demonstrate, business and legal concepts. And you're probably wondering why I do this. Hello to the person who came in on Facebook. The reason why I do this is because it became an offshoot of my business, NPL Consulting. And what I do is I help entrepreneurs and small business owners get their paperwork together, get their infrastructure together. So if you need to register your articles, excuse me, of organization, if you need to have contracts, if you need to know how to hire employees, if you need to know how to protect your brand through trademarks, patents, or copyrights, I help you do that type of stuff. Okay. I provide free consultations if you want to kind of get a better idea of what I do. And you can always go to Linktree/NPL Consulting Firm, Linktree/NPL Consulting Firm, Linktree/NPL Consulting Firm to book that. Okay. Some of the things that I am promoting right now are my crafters contract. I have a lot of you lovely followers who make amazing, unique items, and you get in trouble because you don't have contracts ready for these clients, and then you end up, having to eat money. So I have made a very easy template bundle for you. It is a text document of a contract as well as a PDF guide that has labeled sections so you know exactly what each section means. And it comes with a video guide that I did so that you can see me making the changes so you understand how you can change it. And that is one of the items that is 50% off right now in my e-store if you use the code in the title of today's broadcast. Okay? So that is enough of me shilling my wares. I want to get to the point of today. Like I said, every week on NPL Legal Dish, I take pop culture and celebrity stories and use them to demonstrate business and legal concepts. A lot of you have great business ideas out there, but you don't know, the basic steps that you need to know to make your business solid. And that's what I'm here to do. That's what I do in my business, and that's what I do on this show. I talk about fun stuff. I try to make it as fun as possible. It can be a dry topic, but I think we laugh a lot here. We talk about celebrities. We talk about my fave, Cardi B. Oh, I talk about Cash Doll. And the first story that we're starting off with today has to do with one of our hip hop legends, LL Cool J. Okay. So if you have been watching my videos with any, for a while, you'll know that I did a broadcast where I talked about how LL Cool J was suing the company that puts on the Rock the Bells concert that no longer happens. I guess people weren't going anymore, so they stopped doing the Rock the Bells concert. But they were using Rock the Bells, this company called Guerrilla Union. They used Rock the Bells for their web domain, meaning their internet address, and, on different media aspects. And I remember seeing Rock the Bells t-shirts when my friends would go. I'm not a big concert person, okay? What people might not know, you did? What people might not know about the Rock the Bells concert, I don't know how you do concerts. I do not like being surrounded by so many people. Anyway, is that Rock the Bells, that name, it was actually the name of LL Cool J's 1985 single, okay? And basically, once they started, LL Cool J never actually trademarked Rock the Bells. However, of course, when you create a work of authorship like a song, he has a copyright to Rock the Bells, right? Anyway, so they start doing these concerts, and LL Cool J's like, yo, you're using my phrase. Can you stop? And they were like, no. So LL Cool J sued, and the courts have agreed with him. The court said that he is the exclusive owner of the phrase Rock the Bells. And the company that was doing the concerts, Guerrilla Union, they have to stop using the phrase unless they have his permission. LL Cool J also gets account administration over their website, social media handles, and email accounts. So basically, they have to turn over all of their media to LL Cool J because now he's the owner because he won. They have to turn over any items that have the Rock the Bells logo on it by May 10th, and it's all going to be destroyed. So Guerrilla Union can no longer use the Rock the Bells, brand unless they have LL Cool J's permission. Now, if they try and ignore the court, the accounts will be transferred without their cooperation. Either way, LL Cool J is going to get his stuff, all right? To his credit, LL Cool J did try to settle with them out of court, but they just basically never responded to any of his letters or any of his correspondence. So we sued for infringement, cyber piracy. Hello, Camille Lala 8. He sued for infringement, cyber piracy, and false affiliation. He has since filed a trademark for Rock the Bells, and he even has a Sirius channel by that name now. Okay. As for Guerrilla Union, they have literally never responded to any communications. They didn't respond to any of the court filings, and they don't even have a lawyer on tap. And my guess is that the company went bankrupt and they just don't have the money to defend the suit, on top of the fact that they are no longer doing this concert. So that is the first case that we are in. Camilla, thanks for coming in. If you see the title, you'll see, hello, Bora. If you look at the title, you'll see it's a little different from what I posted on Instagram, but there's actually a live broadcast sale going on right now. If you go to my e-store during the live broadcast and use the code live discount, everything in my e-store is 50% off, okay? So yeah, you can go to gumroad.com/NPL consulting firm and get your 50% off. All right, so we are done with LL Cool J. So the next story we are talking about is we have all seen the as seen on TV label. They even have a store in a mall that's not too far from me, but it's like as seen on TV is like these products that you never really see them anywhere except on TV, right? So, um, Universal Management, this company, they tried to trademark as heard on TV as opposed to as seen on TV because it was a way to market their brand of, music that was basically TV safe that could be synced up with television shows. However, the court has said that their as heard on TV is only a variation of as seen on TV, and it's not anything that is like totally unique because it's just like, okay, as heard on TV, it's music you heard on TV. So basically, they're saying that as heard on TV does not distinguish any particular product. And it just seems to be, a different way to say as seen on TV, which is already a trademark that is out there. So that application was denied. Okay. Hello to whoever's in on Facebook. Say hi. Say hi. Make sure you cash in on the 50% off live broadcast sale. Use code live discount using the website in the description. Get you 50% off everything in my e-store. Okay. Next story we are going to has to do with my Fashion Nova. Fashion Nova cannot stay out of the news. So Fashion Nova, recently they had a bathing suit that was in their store, right? And there is an old California law that says that you as a manufacturer have to put on the label when you expose your customers to, carcinogens, meaning things that can cause cancer or birth defects or things like that. And Fashion Nova had to say that that bathing suit that they were selling was made with materials that had carcinogens in them. And the reason why I bring this case up is because, remember, we don't have trademarks on clothing, right? The only way you're going to tell one red blazer from another is, hi Nicole, is usually the label and then probably the quality. But this California law also requires you to disclose, like, what is the effect of these materials? So maybe, this could be a way to distinguish, the fast fashion that's made with poor quality materials from the high end stuff. Because if I have to tell you that my clothing, which is a knockoff of this high end brand, is made, Fashion Nova is trying to take folks out. If I'm telling you that this knockoff outfit is made with something that could potentially cause you some health effects, that may affect your bottom line. Now, remember, this is just a California law. And I'm thinking that maybe this will spread. Maybe more states will pass these laws where, as a manufacturer, you have to disclose what type of materials you are. Are you exposing me to, dangerous substances? But the fact that a bathing suit would expose you to carcinogens and possibly cause you pregnancy harm, birth defects, or even get cancer, that's crazy. Like, that would really deter me from buying from that brand, right? So it was just a thought that I had in my head. So let me know what you guys think about that, of Fashion Nova being required by California law to put, that their products may contain harmful substances. Like, do you think this is something that every state should pass? Do you think it should be mandatory for every company? Like, let me know what you guys think about that. Also, don't forget to use the code live discount in my e-store, 50% off while I'm on live. I'm taking it down as soon as I get off. Okay. All right. Next story we are talking about is another case of Apple trying it. Apple sued a German cycling path logo. So basically, there is this bike path in Germany that is called Apfelroute, right? I was going to show you guys the picture, but it's on my phone and I'm broadcasting from my phone. But I want you to look up the case of I want you to look up the company Apfelroute. It's spelled F as in Frank, E-L, root, R-O-U-T-E. And look it up next to Apple. Hi, Kayla. And I want you to look at the two logos and what Apple is basically saying, that the Apple root logo is going to, be confused for the Apple logo. Now, the Apple root logo is basically like a red circle, the word Apple root in it, and like a space. Apple's trademark, Apple's logo is a silver apple with a bite taken out of it. If you go and look this case up, I guarantee you're going to be like, Apple is trying it. And I think this is a case of trademark bullying, that just because Apple has the money to go and oppose all of these trademarks, that they're doing it. The same way baby clothes manufacturers disclose whether or not clothes are flame retardant. Hold on. Are flame retardant. Fashion Nova needs to disclose that their clothes contain harmful chemicals. Yeah, I think so too. Thank you for that commentary, Kimberlyn. But back to Apple. So if you remember a while ago, I talked about Apple sued a political party because they had an apple in their logo. They're just going around basically trying to knock apples out of everybody's hands. But look up Apple versus Apple Root. It's a German bike path that Apple is suing for trademark infringement. Okay. Next case is kind of a follow-up to a case that I talked about before. So if you guys don't remember, I talked about Dave Johnson, who sued this movie production that Bill Murray was in, where he played like a sports gambler. And the phrase that he was suing over was, "and down the stretch they come," right? So this guy, Dave Johnson, he's hi tablets. He used that phrase. He said that the movie used it without his, permission. He's got a trademark for it. And then here comes Amazon. Dave Johnson is suing Amazon because they are selling shirts with like a silhouette of a person on a horse, or like a jockey on a horse, with the phrase, "and down the stretch they come." Dave Johnson has sent Amazon a cease and desist letter, but nothing has been said yet. So we'll have to wait and see. This is really a case of David versus Goliath, because this one little man is going up against the empire that is Amazon over his phrase. But again, this is why it helps to have a trademark, because otherwise he would have no standing, and the court at Amazon would be like, "Girl, what are you doing?" All right. Yes. So as we go to the next case, I want to remind you guys, I'm Natalie Pierre-Lewis of NPL Consulting LLC, a business formation firm. I help you get your business paperwork together, doing articles of organization, having contracts, protecting your brand through trademarks, patents, and copyrights, hiring employees properly. I help you get all that infrastructure done. And I am having a sale during my live broadcast. If you use the code live discount in my e-store, the address is in the title, you will get 50% off of everything in my store. And I have things in there as low as $5.97. Go get you some products. All right. Next case we are talking about is the High Times magazine versus Women of Weed. Okay. So here's what happened. In 2016, this woman, she trademarked, someone has a question, hold on. Is there such a thing as a global trademark? So tablets, there's not like one overall global trademark, but there are treaties that allow you. So if I have a United States trademark, because we have treaties with other countries, I can go and apply to have that trademark extended. But there's not just one, blanket trademark for the whole world. You have, hey Versha, you gotta DM me so we can reschedule. So you can have regional trademarks, you can have national trademarks, and there are international trademarks, but there is an application process. It's not just something that's automatic. Okay. I hope that answers your question. Okay. All right. Next case, we are talking about High Times versus Women of Weed. High Times magazine is a magazine amongst cannabis connoisseurs. Now, here's what happened. In 2016, this woman trademarked the phrase "women of weed" for business events and social events, right? High Times in the last few months has been having women of weed events, but the events have been very sexualized. They, feature women who are very scantily clad. And basically, the owner of the Women of Weed trademark is saying that they are tarnishing their brand because that's not what the brand is for. The brand is for business and networking events, and they're using it to, show people's bits in the magazine. On top of the fact that High Times actually wrote about this woman and her work in the cannabis industry, and now they just took her trademark and are using it, to put people's boobies in their magazine. So she sent them 3 cease and desist letters, and they just have basically ignored her. So now she has gone to court to defend her trademark. And this is why it's important, because had she not registered her trademark, she wouldn't really be able to go to the court and file unless she could show that people, there is a definite, portion of the population that associates her brand with that phrase, women of weed. And that's a lot harder for smaller companies to do. All right. Next case. If y'all do not watch Queen's Court, you should. It's so funny with T.S. Madison. All right. Next story is for all you parents out here. If you are a parent in this day and age, at some point you have either touched, made, or cleaned up some of your child's slime. Slime is a very popular entertainment pastime amongst children these days. All right. So this is the case of the Kiwi Slime Princess versus Nickelodeon. All right. So there's this girl. She lives in New Zealand. She's like 12 years old. And she makes slime. So she applied for a trademark for Slime Princess, right? And then here comes Viacom. Remember, Viacom is a huge, entertainment company. They own Nickelodeon. Viacom basically got word that she was applying for the trademark for Slime Princess and was like, hold up, we don't think we like that. Viacom through Nickelodeon owns the trademarks to the word slime and Nickelodeon slime. Okay. And they're saying that there's going to be confusion because, they dump slime on the celebrities and things like that. So this little girl, she started her GoFundMe because she wanted to defend her trademark, and it got a lot of media attention. And because of the negative media attention, Viacom has decided to drop this lawsuit against her. So this is the power of the public and using the power of, media to help the little guy stand up to the big guy. And as well, if you think about the Nickelodeon slime and slime trademarks, what areas are they trademarked for? Are they actually making slime? Are they what is this girl's trademark supposed to be for? I think this is another case of kind of trademark bullying. It's like this little girl, she's 12 years old in New Zealand. Like, who's going to New Zealand for, who's going to mistake this little New Zealand girl for Nickelodeon, right? And they're also saying that there's a possibility of confusion that people would think that she is affiliated with Nickelodeon. I mean, whatever. I guess you got to defend your brand where you can, right? Okay. So the next case that we are talking about, actually, we're moving a little bit away from, it's a blend of trademarks and contracts. And this is an example of how important contracts are and how important language is. And I'm going to do a shameless plug. I know that a lot of you make unique items, and I hear a lot of you getting burned because you don't have contracts. Take advantage of the live discount code right now. Go pick up the crafter's contract for 50% off, okay? You're not going to find a lower price. Tablets has a question. Still, it is a bit oppressive for small businesses. High level of responsibility to monitor violations in the biz owner. Yes, it is a big responsibility. But if you have taken the time to protect your work, you should want to take the time to be vigilant about it as well. It's like, you buy a house, right? when you buy your house, you don't leave all the windows and doors open for somebody to come and take your stuff. You take precautions to lock your house. You take precautions to make sure your windows are closed. Maybe you put in a security system. Maybe you have armed guards, depending on where you live. So it's the same thing. Like you have to protect your stuff because nobody's going to protect it for you. If you go into these Etsy stores, a lot of these Etsy stores that are selling knockoff items, the reason they have gotten away with it is because the original owners of the trademarks just haven't caught it yet, right? And Etsy's not looking out for it. These guys are just, they're winging it until somebody shuts them down. So the minute somebody goes to Etsy and says, hey, this person is infringing on my trademark, their store gets shut down. The thing is, there are so many of these stores that, it's hard to keep track of them all. But yes, it is a hassle to keep track of your trademark, but it's part of the responsibility. You can't have the benefit and not take the responsibility with it. Okay. All right. Okay, so like I was saying, this case is a blend of trademarks and contracts. Why contracts are important. Go get your contract 50% off. This is the case of a guy named Scold versus the company Galderma. Okay, so this guy Scold, he invented a drug delivery system for skincare called Restoraderm. But he needed a company to help him develop it and, get it out there. So he was shopping around. And he signed a letter of intent with this company called Collagen X, right? But when he signed the letter of intent, they said, hey, if you come work with us, we own your trademarks. And he said, okay, right? So they go into the letter of intent and they're working, they're going forward. And then they decide to do a licensing and development and production agreement. And again, this contract says, we keep all the trademarks. Okay. He signed it. No problem. Okay. So the company Collagen X, they filed a trademark for that phrase, for that word Restoraderm. But then, in 2004, they signed another development agreement with this guy, but it no longer had the clause that said that they kept all of the trademarks. This is the third contract they've signed, right? Okay. Now, 2008, this company Galderma buys Collagen X, and they basically tell the guy Skull, we don't want to work with you anymore, but they kept using the mark Restoraderm. So, Collagen X was working with him, things were fine. Then Galderma comes in, and it's like when another company buys another, and they just kind of like fire all the staff, they fired Skull, but they kept using his mark Restoraderm. So Skull was like, well, if you're going to fire me, you don't get to use my mark. And he sued for infringement and breach of contract. It didn't state what the contents of his contract were, but there may have been, maybe he was hired for a specific length of time. Anyway, so Galderma, they basically said, well, you said when you signed these contracts that we could keep the trademarks. And the judge said no, because the last contract that he signed in 2004 did not have that clause in it that let them keep the contract. So this is why it is important to read everything carefully. Read it twice. Make sure it's thorough. Know what you're signing, okay? But yeah, that is and Scold got his trademark back. So he gets back Restoraderm. So that is where trademarks and contracts come in together, guys. All right. And again, if you need a contract, if you make unique items, go use my discount code in the e-store and get 50% off. Okay. Next case we are talking about has to do with the title that I posted earlier today. And it is the case of Off-White, the company. If you remember, I talked about Off-White last week. They sued a company that takes streetwear and makes it like for kids. And they won. However, Off-White is now trying to trademark the use of red zip ties in their clothing. Okay? So Off-White apparently I did not even know this was a brand until like a few weeks ago. They like to put quotations around words on their products. So like it'll be like shoelaces with quotations around it. And then they also put red zip ties on like their accessories and stuff. They sued this company called Rostaclot for bracelets that had red zip ties on them and had shoelaces in quotation marks. Now, Off-White has no federal registration for quotation marks or red zip ties, but they say that they have acquired it because of marketing and, and they basically have a common law trademark, okay? They filed an actual application in July of 2018, which was rejected at first because the attorney who was looking over their application said that the red zip ties are not inherently distinctive. The quotation marks are not inherently distinctive. What that means is nobody looks at this and sees your company. Nobody looks at red zip ties and thinks Off-White. Nobody looks at quotation marks and thinks Off-White off the bat. So what they are asking is that Off-White shows their work and keeps and proves that they have acquired essentially street cred to be able to trademark red zip ties and quotation marks. Okay. We only have two more cases to talk about. So this case is about patents. Guys, if you remember, I have a patent ebook. Use the discount code to get it for 50% off. Those of you looking to get into the cannabis industry, particularly if you are breeding strains, a lot of cannabis companies are looking to the little used plant patents. Plant patents are not very popular. They're usually utility and design patents. Plant patents give you 20 years of exclusive rights. To your plant. Like you can say basically that nobody else can breed this. This is mine. You can only get it from me. Okay. And it'll let you license the strain for commercial use. Last year, there were actually 39 patents issued for cannabis strains. So it's getting to be a real thing. Hello, Joint Meditations. Oh my gosh, I was just talking about this case. So I was just saying how a lot of cannabis companies are using plant patents to patent their, signature strains now. Excuse me. So this is something very exciting because plant patents are actually not very popular, but the cannabis industry might actually widen their popularity. Okay. And the last case that I am talking about, before I do that, I want to remind you guys that use the discount code while this is live and you will get 50% off of all of my products in my e-store, okay? So the last case we were talking about is a case of Apple versus Android, okay? So specifically Samsung. Samsung has filed a trademark for the phrase Play Galaxy Link. And the industry that it is trademarked for is for a game streaming service for smartphones and virtual reality gear. And Apple basically posted this in their Mac Rumors website, and they're saying that they're probably doing this to compete with Apple's upcoming arcade or present arcade. I don't know. I don't keep up. But anyway, and they are estimating that it will probably come out August 2020 with the release of the Samsung's Note 10. All right. So those are all the stories that we have for this week. I hope that you were able to pull, that I was able to pull the lessons for you and make them more tangible. Again, we're about to end in a couple minutes. This is your last shot to get the 50% off the store. If you have any business formation needs, please hit me up, DM me. I am always here for you. or you can email me at nplconsultingfirm@gmail.com. Visit my, see all of the things I do, like my podcast, my ebooks, my video trainings at linktree/NPL Consulting Firm, linktree/NPL Consulting Firm, linktree/NPL Consulting Firm. That's all I have for you guys. Good night.